All right, this is the cases of the people of the state of Michigan versus Carlin Abigail Gunnett, case number 254578 FY. We are here for a PCC on that file. And 244039 FY, we're here for a probation violation. For the record, the court does have a conflict with the probation violation file, but it looks like Ms. Gunnett is signing the waiver. Is that correct, Mr. Harrison?
It is. It's a product of our discussion earlier this morning. If I may, we intend to resolve both files today, Your Honor. We're processing everything.
All right.
The date's going to be.
Do you have a word file?
I think it's done by the prosecutor. Nothing.
Other than I give them the.
All right, Ms. Gunnett, first things first, I want to turn to the probation violation file. Have you had adequate opportunity to discuss the conflict that I have on that file with your attorney? And that conflict being that I was the elected prosecutor at the time that you were charged with that offense. And as such, I would have a conflict with that. Just a moment. Mr. Carnes, was she on a delay of sentence or something in this case? Ida. Okay, so because there hadn't been an adjudication, that conflict would still follow through. Do you understand that? I'm sorry?
Yes, sir.
And have you had adequate opportunity to discuss that with your attorney?
Yes, sir.
And the signature that on this form that is waiving the conflict, did you sign that form,
Yes, sir.
Mr. Carnes?
I misspoke. It's a delay of sentence.
It is a delay of sentence.
It's delayed. I thought, okay.
All right. It still would not be appropriate for me to handle that because there would be some sort of benefit at the end of that delay. And so that conflict would still exist. Does that make sense?
Yeah.
I can hardly hear you.
Yes, sir.
Do you want some more time to talk to your attorney about that?
Exactly.
Mr. Harrison, why don't you take a minute and talk with her?
I'm sorry.
No, you're fine. No need to apologize.
Sort of messed up. So here's another part of it. Yes. Yeah. No, it's okay.
Okay.
Ms. Gunnett, have you had the opportunity to discuss that issue further with your attorney?
Yes, sir.
And after that discussion, do you still wish to waive the conflict that I have?
Yes.
All right.
Thank you, sir.
All right, then I will go ahead and I will sign the waiver. Case will be transferred from the visiting judge docket to my docket. Mr. Carnes, I presume I know what the resolution was with the delay of sentence, but was it a dismissal at the end of the delay? Judge Van Alt's notes aren't clear.
Your Honor, I'm going to assume it was a dismissal based on the notes, because typically we would have a reduction if that was the plan, so. I would assume that was the plan.
Mr. Harrison, did you represent Ms. Gunnett on the prior case?
I did not.
Do your notes indicate what would happen at the end of the dismissal?
I was laboring under the presumption, unfortunately, that it was HIDA, which conceptually would have led to the same result. So I think I got to the right place, maybe by an alternate route, but yes, I was aware of it.
All right, so it sounds like we're in agreement that if she were successful with the dismissal, with the delay of sentence, the case would be dismissed.
Yes, Your Honor.
All right.
Yeah, or whatever mechanism, yes.
All right. So as I said before, we're here for a probation violation on that one. And on the new file, we're here for a probable cause conference on a police officer assault, resist, and obstruct, and a domestic violence. Is there any resolution to either one of these matters, counsel?
There is, Your Honor, and they are sort of interdependent.
Your Honor, it's my understanding she's going to plead guilty to domestic violence in the new file with a Killebrew sentencing under 4A. There's no agreement on the probation violation file.
But we do have a recommendation, so I'm not sure where that leaves us.
What is your client's intent with the probation violation?
The intent would be to simply face down the inevitable, that there was a subsequent event, the current domestic for which she stands accused, that we would seek to resolve with treatment under 4A. So in the event that
the probation violation is for resist and obstruct in a domestic violence. Is she going to plead to those? Are we going to have a hearing on it? Are we dismissing one and going with the other? What are we doing?
Your Honor, I'll accept it, the guilty plea to the domestic violence for both files. So, sorry.
And do away with the
Okay.
RNO?
Yeah,
that makes sense. Thank you, Mr. Carter. That certainly cleans it up.
So now that brings us to the elephant in the room. She's on a delay of sentence, hasn't been successful with the delay. You're asking to put her back on essentially another deferral. Why am I going to go along with that?
I think I can explain that. Would you like to?
Let's address that first. Yeah.
Offer proof, if you will. The department, and I don't want to speak for Ms. Bismack, she is present in the room. But in conversations with my client and reading the recommendation that was issued from the department, it seems clear that she was doing remarkably well. She had been attending counseling. She had been a couple of the other requirements that seemed to her mental health was of primary importance. There was some issue surrounding testing that I'm not 100% sure. The court could inquire of Ms. Bismack in that regard.
Mr. Harrison,
Okay.
not to interrupt, but to interrupt.
Please,
I did miss that as a violation as well. She has a violation for failing to submit to a PBT.
Right.
So she's got the 3 violations.
I would ask that she admit to that. That was at the same occurrence as
Right.
the TV incident.
Okay.
Yeah. I've been trying to formulate this in my head because I knew this question would come up, but I'm glad it's coming up now. Why should you do this? Well, you should do this because what she really needs is the counseling, the mental health counseling, and the structure provided by some form of supervision. She didn't quite get to the end on this one. With regard to there being another incident involving domestic violence. But she's made such significant progress, however, I don't believe this is simply a matter of you've seen this time and time again in this court where you have a defendant who's on probation for a drug case and then 6 months later, they get caught doing drugs again. I think this is a little bit more nuanced than that, in that the DV in question was the product of her having a mental health crisis. But which is not, we're not stating that to say that she doesn't have the capacity or something along those lines. She's acknowledging that, or she will acknowledge that there was an act of domestic violence, but it was born out of a mental health crisis more so than other motivation, let's say. So I guess what I'm saying is I would simply like to extend, in a manner of speaking, the probation situation so she can get to the end, she can complete the counseling, and she can continue to monitor her mental health. And I told her this, and we spoke briefly this morning again. If she fails this time, we all know what the consequences are gonna be. There's no turning around, there's no second chance, third chance. This is it. We've extended this accommodation to her, or presumably the court will, I'm speaking in past tense, that we understand that the reason she's in court has more to do with her recovery and mental health and counseling and that sort of thing. And that for whatever the reason, she needs additional time or services in that regard. But that presumption will disappear if there's a subsequent violation. She knows how high the stakes are.
Do you have any records to substantiate the mental breakdown?
I don't, but it's clear from the police report that she was distraught and et cetera, and that's consistent with, I think, the observations of the probation department. I don't want to speak too much further in that regard, being as she's right here in the room. She could also, I think, be in a position to describe it to you. We've certainly discussed it at some length privately.
Yeah, 100%. I've always been on medications, they've been pretty high doses. They help a lot, just to even, the playing field of like surrounding factors. And like I have a high anxiety, bipolar, and schizophrenic, so I've been pretty quick. Like at age 18, I've been in 3 mental hospitals.
Ms. Bismack, not to put you on the spot, but I can't help but notice your recommendation in the probation violation is to terminate probation. If everything is as rosy as Mr. Harrison puts it, why terminate?
Well, Your Honor, I'm not sure what recommendation he was reading, but it says in mine that we have 3 different in-house show causes. We have worked extensively with Ms. Gunnett. We've been lax due to her mental health. I know that she was with CMH. She was on and off her meds. When we start having issues, she forgets to report for testing, her reports, call in. CMH said that she has not been consistent with her refills, and those will be up there, or they were up in the beginning of September. So I'm not sure where she's going to apply for more medication. I do believe she does need some stability, but we have tried our hardest with her.
Mr. Harrison, I'll turn back to you.
It has been a struggle. I did read the same recommendation, and frankly, again, in all candor, she recommended 45 days in jail along with termination, so I knew she wasn't happy. I didn't mean to paint the picture that she thought everything was hunky-dory.
So, Mr. Carmen,
Your Honor, I'll just say, looking over her probation notes, it appears she did well for the first 4 months and then started missing some tests. She completed her course of mental health treatment, got off the meds, and then this happened. But my thought is she's faced the consequence of some time in jail. She can either return to no alcohol, regular testing, back with compliance with CMH and get through this without public domestic violence conviction. Or I sincerely hope this doesn't happen, or she'll violate probation and wind up spending more time in jail and have a public domestic violence conviction on the record. That was my thought in making this. I was aware of the mental health background, and I suppose that's why that was a big factor in making the offer for it.
Is your victim in favor of the 4A?
Your Honor, we've had no response from the victim.
The victim has historically been supportive of her struggle. They are a couple. They do, at least as far as we know, intend to have a future together, and did advise her that there would likely be a period of separation imposed by the court, via some kind of no contact. And I think that's probably a good idea as well, depending on the resolution of the case.
Take a look at something here. So, Mr. Carnes, when you say you've had no contact with the victim, do you mean that he hasn't returned the victim impact packet?
He has not returned the victim impact.
Has there been any reach out to him regarding?
There has been. I'm following up with this script as far as what else has happened. All the notes.
The reason I ask is because the statute says in consultation with the victim. So I guess I'm questioning whether or not you've actually either had or tried to have that conversation with the victim.
I've attempted, have not been successful.
All right. I guess what I'll do is we'll hear the plea. I'm going to request a PSI, Ms. Bismack, and I'll make a determination after I hear that. I'll be very upfront with everybody. Where things sit today, I'm probably not going to go through with a 4A unless there's more presented to me either in the PSI or in the sentencing memorandum or more proofs than what I've heard today. But, and so I guess in that case, I'll turn it back to counsel. Do you want to reset it for another PCC to get the proofs? Do we want to take a plea? How do you want to proceed on this?
I guess perhaps we should reset it simply so we can touch all of the bases here, because I understand the dilemma that poses to the court. I understand everybody's position in here, and I'd like everybody to be as comfortable as possible with what I'm asking them to do. Does the probation department have any of those types of records with regard to your counseling or anything like that?
I have a letter from CMH when she was attending.
Okay.
So my thought process is this. Well, Mr. Karn says she was successful the first 4 months, that leaves 6 months that she hasn't been successful. I've got a recommendation that's telling me judge, don't keep her on probation, terminate her and give her a jail sentence. And so those are the issues that I think we need to address as to why we've already given her one chance. Why are we gonna give her another one when I've got probation's basically saying there's nothing else we can do? So we will reset this for PCC on Monday. And I will turn then to the probation violation file. Do we want to handle that today, Mr. Harrison, or do you want to reset it with PCC?
I think, I would prefer to reset everything, at least preserve some chance of it.
We'll reset that then for Monday as well. Anything else for the record? Mr. Harrison?
Nothing to, thank you.
All right. You're adjourned. Is that complete? The morning docket?